How do you decide on the best path for sponsoring your foreign national spouse or partner for permanent residence in the United States? That's what we're talking about on today's episode of Sumner School Family Immigration Basics. My name is Emily Sumner with Sumner Immigration Law. Let's get into it. So as you may know, if you are a US citizen and you want to sponsor your foreign national spouse or partner for permanent residence in the United States, there are three basic options through the marriage-based or family-based green card process. We talked about each one of those options in a bit more detail in the three previous videos. So if you haven't checked those out yet, make sure that you do after you watch this video. Just as a reminder, the first option is the IR1, or sometimes called the CR1 process. That refers to the process of a US citizen sponsoring their spouse for permanent residence in the United States by filing the I-130 petition. Then the case moves to the National Visa Center. Then the foreign national spouse applies for what's called an immigrant visa at the US consulate overseas. Then they enter the United States as a green card holder. The second option, potentially, is called sometimes the one step. That means filing the I-130 petition and the I-485, the application for the adjustment of status or the green card application here in the United States. That option is available for married couples where the foreign national entered the United States with documentation, with a visa, for example, and is otherwise eligible to apply for adjustment of status here in the US. So a lot of times our clients who use this particular process, the foreign national perhaps is here in the United States on an F1 visa, on an H1B visa, any number of other visa classifications, or they entered the United States at one time with a visa, for example, a visitor's visa. And it's possible that they have overstayed that visa and they now are married to a US citizen and are applying for permanent residence. The third option potentially is the K-1 fiancé visa. That is the process where a US citizen would file a petition saying that they want to sponsor their foreign national partner for permanent residence in the United States. Once that's approved, the foreign national partner, fiancé, would apply for the K-1 visa at the US consulate, then enter the United States with that K-1, get married within 90 days, and apply for the green card. So that's a high-level overview of the three basic options. That's a lot of information, right? So many processing times, documents, options, forms, timelines, all of the things. So there's a lot to consider when you're trying to make that decision about how to proceed. As always, the information in this video is not legal advice, but I can share with you some things to consider, to think about as you make this decision. One is, are you married yet? If you are already married, your only options are possibly the IR1, the immediate relative visa, immigrant visa, or conditional residence. And we'll talk more in future videos about conditional residence. That refers to when you've been married for less than 2 years at the time that the green card is issued. So that's the reason that it's sometimes called a CR1, because you could get conditional residence instead of permanent residence. So the IR1 or CR1 visa is one option. The other option potentially is filing the I-130 and the I-485, filing that one step here in the United States. In other words, if you are already married, then the K-1 visa, fiancé visa, is not an option because it's only available for fiancés. And if you are already married, you can't go through that process. If you are not yet married, you still have the option of all three. It's just that if you're going to pursue one of the first two, either the immigrant visa processing or filing the one step here in the United States, you have to be legally married before you file that I-130 petition. That marriage, that wedding does not have to be anything big. You just have to be legally married, meaning that you were married in a place where the marriage was legally recognized when you were married. So that's consideration number one. Are you married yet? And if you're not, then like I said, you have the potential of considering the K-1 as well. A second consideration is where in the world is the foreign national now? A lot of times our clients who pursue the IR1 or CR1, the consular processing option, immigrant visa option, are in a situation where either both of them are living overseas, perhaps together, or the foreign national is living overseas and the US citizen is here in the United States. But either way, the foreign national spouse is living outside of the United States, and so that's the logical option. They choose to pursue the immigrant visa option because they're not here in the United States and really don't have a way to enter the United States at this time. Another consideration is how quickly you want to be together. And let me go back to the previous consideration, actually. I said, where in the world are you? I talked about if you're overseas, if you're here in the United States, if the foreign national is here in the United States, it may make sense to go ahead and apply for submit the I-130 and the I-485. So as I said a few minutes ago, can be a really great option for foreign nationals who are here on an F1, an H-1B, an L, a TN, any number of other visa classifications. It can potentially allow them to stay here in the United States and continue working, assuming that there's a way for them to continue working with authorization, work authorization. But that can be a great option for individuals who are already here in the United States. One thing to note, it is not permissible for a national to enter the United States for the purpose of staying and getting married. That is considered a misuse of the visa classification, can be considered misrepresentation or fraud. So for example, if a person were to enter the United States on ESTA or B1, B2, and then immediately turn around and get married and file for the green card, that is not advisable. Talk to an immigration lawyer about your specific plans to make sure that you have a clear strategy in place that will not put you into a risky situation. So, like I said, the second consideration is how quickly you want to be together. A lot of times when I'm talking to a couple that is not yet married, that's what we're talking about. We're talking about the option of either filing for the I-130 and consular processing or the K-1 fiancé visa. The processing times, of course, shift all the time, right? So historically, the K-1 has been faster in the sense that in general, it's going to be less time from the time you file that first petition to the time that the foreign national is able to enter the United States. In general, historically, that's going to be a shorter time period for the K-1 option than it would be for the I-130 and consular processing for applying for the immigrant visa. Once COVID hit, that changed. And the processing times for the I-129F, the petition tied to the K-1, became a lot longer. Consular processing times shifted. So it's something to pay attention to. Make sure that you're talking to a qualified immigration attorney to talk through what those timelines realistically would look like. So you're talking about the timelines both with USCIS, the processing times there, and the processing times at the National Visa Center, and the processing times or waiting time for the appointment at the consular appointment, the interview appointment at the U.S. consulate overseas. So there are multiple agencies that we're dealing with, multiple waiting times, and they change all the time, which makes the process difficult sometimes to predict precisely how long the wait is going to be. I would say in general, and this is just a general observation, not a guarantee by any means, but in general now, when I'm having this conversation with clients, if their goal is for the foreign national to enter the United States as soon as possible, to be together in the US as soon as possible, and if they're not married yet, then the K-1 is generally the option that they choose, because right now, as of April 2025, in general, that processing time, the time from the time they file that first petition to the time the foreign national is able to enter the US is generally shorter than if they were to pursue the I-130 and consular processing. So second consideration, how quickly do you want to be together? How important is that to you? Another consideration is work and travel permissions, especially if the foreign national is here in the United States. So by that, I mean, and I kind of referred to this a minute ago, that if you're here in the United States, for example, in a work visa classification, for example, an H-1B or a TN or an L, it may be that you're able to stay in the United States, keep working on that visa classification, and apply for the marriage-based green card at the same time without an interruption in your work or your ability to travel. However, that is not always the case, especially depending on how long your current visa status is going to last, and then depending on your classification. So there are some classifications that are dual intent that allow you to travel in certain situations, others are not. We actually have a video on dual intent in our Sumner School Business Immigration Basics series, if you're interested in that. But keep in mind, it's too much to get into in this particular video, but keep in mind that there can be restrictions on work and travel depending on your particular situation if you're applying here in the United States. The opposite is true as well, right? If you're outside of the United States, let's say pursuing the I-130 and consular processing or applying for the immigrant visa, a question is always, can I, as a foreign national, enter the United States on, let's say, a visitor's visa, for example, to visit temporarily while all of this is going on? That's a question to discuss with your immigration attorney and get a read on the facts of your particular situation and what the current environment is. I have always said that it may be possible in your particular situation, but there's always a risk because, especially depending on the type of visa that you're using to enter the US, because you do have that I-130 petition approved or in process, and that can affect your chances of being able to come into the United States, being admitted to the United States. Remember that just because you have a valid visa, that does not guarantee your admission to the United States. It allows you to apply for admission, and then the officer at the port of entry can decide to let you in or not. So the fourth consideration is the costs and the steps, and I would say the overall timeline that you're willing to tolerate. And so, a lot of times you don't have a choice. But by that, I mean there's a big difference between there can be a difference between the timelines and the costs and the steps that are required for the I-130 and consular processing versus the K-1. By that, I mean with the I-130 and consular processing, you're still looking more or less at I consider it three steps. You're filing the I-130 petition, then the file is transferred to the National Visa Center. You submit documentations there. I consider that the second step. And then the foreign national spouse applies for the immigrant visa at the US consulate overseas. So I consider that the third step. But then once they have the immigrant visa, they enter the United States as a resident of the United States and should receive the green card in the mail within several months of entering the United States. So there's not an additional step that they have to take other than waiting for the green card once they're here. That is not true for the K-1. For the K-1, the foreign national, the first step is the US citizen would file the I-129F. The second step is the foreign national applies for the K-1 visa at the US consulate. Third step is they use that visa to enter the United States, get married to that same US citizen who sponsored them for the K-1 within 90 days, and then apply for the green card. So it's a separate, once you're here in the United States, it's a separate application for the green card once you're here, and it's a separate waiting game. The other consideration for that, as far as timelines, if you choose the K-1, is once you apply for the green card here in the United States, you also can apply for the work authorization and travel document. But remember, you're not authorized to work or travel outside of the United States, to work in the United States or travel outside the US until those documents are approved. And those processing times can take months to do. Whereas if you had entered on the immigrant visa doing the I-130 and consular processing, you'd be able to work and travel immediately. So that's another consideration. So as you can see, there are lots of things to consider when you're making this decision. If you are beginning to navigate this process and you have questions, or if you're looking for an experienced, empathetic, dedicated attorney to help you through the process, we are here to help. My name, again, is Emily Sumner with Sumner Immigration Law. After this video, we'll have a screen that has our contact information with information on how you can contact us to set a time for an initial consultation to take the first step on this journey. If you have found this video helpful, I hope that you will share it with a friend or family member and subscribe to our channel so that you don't miss our next video. Until next time, my name is Emily Sumner with Sumner Immigration Law.